You are about to make a decision that can cost you everything you've built. Right now, someone in your business throws a worker on the wrong tax form. You might not even know it yet, but the IRS does, the Department of Labor does, and in 2024, they changed the rules in a way that most Florida business owners still have not figured out. And here's the part that should keep you up at night. The contract you had your worker sign, that doesn't protect you. The LLC they showed you, that doesn't protect you either. The CPA who told you it was fine, that cannot protect you when the audit letter arrives. There are 3 letters that decide whether your business survives, and most owners are picking the wrong ones for reasons that feel right and are completely wrong. By the time we're done, you'll know which workers in your company are ticking time bombs and the one document you might have already signed that builds a lawsuit against you and the federal shield almost no one tells you about. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. Now, I've handled worker classification audits for Florida business owners for years, and the owners who lose are not the careless ones. They are the ones who thought they had it all figured out. All right. Let's dive in. Let's start with the trap itself. I call it the 3-letter trap. Business owners think the choice between 1099 and W-2 is theirs to make. Well, I'm here to tell you it's not. The IRS, the Department of Labor, and your state agency all get a vote. Actually, they get the only vote. You can sign a contract calling your worker anything you want. Astronauts, pirates, independent contractors. The label means nothing when the underlying relationship looks like employment. And here's where it gets interesting. The federal government uses the common law test. The test breaks down into 3 categories I call the control trifecta: behavioral control, financial control, the type of relationship. Behavioral control asks who decides when, where, and how the work gets done. Financial control asks who supplies the tools, who sets the rates, and the type of relationship asks whether the work is a core part of your business. You're probably already running the math on your own workers. Well, good. That's exactly what you should be doing. The reason why is that the moment one factor tips towards employment, you have exposure. Not maybe, not might. You do have it. In 2024, the Department of Labor finalized a rule that made all of this even more dangerous. The DOL final rule on independent contractor classification, which took effect back in 2024, restored what attorneys call the economics reality test. 6 factors, no single factors matter more than the other. The whole picture decides. So stop doing this right now. Stop assuming that because your worker has an LLC, they are automatically a 1099. The DOL does not care about their LLC. The IRS does not care about their LLC. I've seen owners lose audits over workers who even had an EIN number, business cards, and even other clients. The economic reality test looks at whether the worker is, in fact, actual practice in business for themselves. Hey, quick pause here. If you're finding this information valuable, go ahead and hit that like button. It helps this video reach more business leaders who could use this content right now. And if you're not subscribed yet, subscribe now so you don't miss the next update on Florida business law. Now let's get into the part nobody wants to talk about. This is the misclassification cascade. When a worker is reclassified, you don't just owe back payroll taxes. You owe the employer your share of FICA. You owe unemployment taxes, penalties for not withholding, penalties for not paying overtime under the Fair Labor Standards Act. State agencies pile on. Workers sue for benefits they should have received. Class actions get filed. One audit finding becomes 10 reclassifications. 10 reclassifications become a 6-figure bill. However, there is one shield most business owners have never even heard of. This is Section 530 of the Revenue Act of 1978. I call it the 530 Safe Harbor. When you have consistently treated similar workers and independent contractors, when you have filed all required 1099 forms, and when you have a reasonable basis for the classification, the IRS cannot reclassify them. Congress wrote it specifically to protect business owners who acted in good faith. Now, about that document I mentioned, it's the independent contractor agreement that uses W-2 language. Mandatory hours, set scheduled, required uniforms, exclusive services, non-compete clauses that prevent the worker from having other clients. Every one of those provisions argues completely against independent contractor status. Plaintiff lawyers love these agreements. The document itself becomes the evidence. When you sign an agreement that calls someone a 1099 contractor and then strips them of contractor-like freedoms, you have built the case for them. The form SS-8, which is what a worker files to ask the IRS to make a classification determination, gets decided in their favor based on your own paperwork. Now here's the rule that actually protects you. When the work is core to your business, hire W-2 employees. When the work is project-based, specialized, and the worker truly runs their own business, use a 1099 and document the relationship to match the reality, not the label. Pay what you owe on the front end instead of on the back end with penalties. Now, if this video helped you, hit subscribe so the next one finds you when you need it most. I'm Santiago Cueto, your Florida business attorney. Watch this next. 5 LLC mistakes you need to avoid.